in this production of documents. This statement does give a running balance in the account, and on September 15th, the balance in the account was $5,509.38. I request that the court move Exhibit I into evidence.
Any objection to Exhibit I being admitted at this time?
Pursuant to CP 170.1, Section 6A3 and 3A, judge who has personal conflict of interest with the party in the case must recuse themselves. We cannot proceed.
Non-responsive, repetitive, cumulative.
Sustained. And at this time, Exhibit I will be admitted.
I'd like to draw the court's attention to Exhibit J. This is a Chase account ending in 1619. In the name of Mr. Mars, the document was produced by Mr. Mars in response to a document request. On September 15th, there's a running balance on the statement. The balance in the account is indicated as $7,020.25. I request that the court move Exhibit J into evidence.
Mr. Mars, any objection to Exhibit J being admitted?
Objection, Your Honor. I state on record that Judge Flint has obvious, undeniable, impermissible personal conflict of interest with petitioner and is legally obliged to recuse themselves from this case. Thank you, Your Honor.
Over objection, Exhibit J will be admitted.
So I've run the math on those numbers, and the totals in Ms. Mars' accounts on the date of separation were $679.59. The total in Mr. Mars, the counts in Mr. Mars' names, was $14,470.63. To divide those with offset, to divide that equally, husband would owe wife $6,895.52.
Objection, Your Honor. Those numbers do not
Mr.
include
Mars,
balances.
That's not a legal basis for an objection. Again, I'm going to give you an opportunity to explain why the court should not find that $6,895.52 should be awarded to Ms. Mars. But before we go any further, Ms. Mars and Mr. Mars, please raise your right hand, be prepared to be sworn. Ms. Mars, please raise your right hand, be prepared to be sworn, and unmute your mic.
Good morning. Do you both solemnly state, under penalty of perjury, the testimony you should give in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Yes. Thank you.
Thank you. And now that you have been sworn, Ms. Mars, is there anything different or anything additional you would like to add with regards to what your attorney has represented as an offer of proof, information that you would otherwise provide?
No, so far nothing.
Thank you. So with regards to the amount, Mr. Mars, what is your position about the division of the bank accounts?
Your Honor, may I present evidence?
You're listed as a presenter, so if you would like to share your screen and show documents, you should feel free to do that.
Okay, let me try this.
And actually, I'm going to ask you that you hold your thought. It looks like Ms. Roberts somehow got dropped from the meeting. I'm going to wait for her to log back in.
Okay, Your Honor, please let me know when you see my screen.
Okay. I can see your screen, but we need to wait for Ms. Roberts.
Thank you, Your Honor. Could you please confirm what do you see on the screen?
All right, Ms. Roberts, we noticed that you had dropped from the screen. And so, All right, so the court had sworn in the parties, and now I'm allowing Mr. Mars to present evidence on the issue of the bank accounts. Mr. Mars, your question was, what can we see on the screen? It's a document titled Equalization Payment Calculation Sheet.
Thank you much, Honor. So you practically speaking can read from the screen. So from this sheet that is legal document, I present you that we have summary of community balances on the date of separation that was $67,000, $67,729.96 of negative balance of community balances. With community assets, which Ms. Roberts stated probably right, 4,000.
Objection, this is not relevant to the bank statements.
Objection.
Sustained. Mr. Mars, Ms. Roberts, please go on mute. All right, Mr. Mars, what you're about to provide the court and the other side is more or less a settlement discussion. It puts everything together and suggests what should be divided. That is not the way we handle it during trial. During trial, we need to break up each specific issue. And so the specific issue we're addressing right now is the bank accounts.
Absolutely, Honor. May I present your bank accounts?
What portion of the 67,000 is bank accounts?
Very good question. Let's check. So on the page 3, we do have balances related to specific accounts, which show Chase debit, Chase savings, and exactly as Ms. Roberts requested, $2,673 in Chase, $420 in Chase savings, Bank of America $477, Chase credit $8,555, right, 500 something. Bank of America $763. Those are already debts, right? So Bank of America $5,594. It's on the date on September 2022, on the date of separation, order date of separation, that commemorates memory of violence against 95 years old senior woman with disabilities, who was put into terminal condition by respondent by kicking out from home senior woman with disabilities violently.
Mr. Mars,
Apologies.
as I said, anytime one side says objection, the other side must pause so the court can respond. Ms. Roberts, what is the basis of your objection?
This is not a bank statement. I have no idea where these numbers came from. It lacks foundation.
May I present foundation, please?
Yes, the objection is sustained. The court is not going to consider the numbers that you've provided because they lack foundation. But yes, I will give you the opportunity to provide the foundation, the basis for these numbers on this sheet.
Yes, Your Honor. So with that said, this is evidence number 28 in evidences for final trial brief, amended 4. Returning to numbers, I would kindly ask you to rememorize those numbers because we will be checking those numbers with actual bank statements that Ms. Roberts requested. So we do have petitioner's balance of $67,977.14. Petitioner's assets of $3,570.77.
Objection irrelevant.
Sustained. We've already covered this grounds, Mr. Mars. Please focus in on providing a basis for the numbers. So bank statements, some kind of proof as to why those numbers are on this sheet of paper.
Thank you, Honor. Did you capture those numbers? Are we ready to go through bank statements? You saw petitioner's debts $71,547.91, and respondents' assets from those very evidences.
Sustained.
And respondents' assets $617 and debts
Objection, irrelevant.
$370.
Sustained.
Thank you, Honor. Now let's go through bank statements. And we will start from Amazon Synchrony Bank on October 13th, 2022. And we have balance $844. This is evidence
Objection.
24. Evidence
Irrelevant.
24.
I believe that is a credit card statement.
Sustained. So again, Mr. Mars, I don't want you to waste your time. It looks like now you have pulled up a bank statement of some kind. Actually, no, this is another credit card statement. We are going to discuss the credit card debt separate from the bank account. So let's focus in on the bank account.
Okay, Honor. Is this... Actually, I have a question. Why court is discussing separate assets, separate bank accounts, credit and debit accounts, while we should address balance of assets, of community assets and debts? But with that said, please see bank statement for card ending in 84 for September 15th to October 2022 with a balance of $763, right? Okay. Another card balance $74. Another card balance is $5,594.57.
Mr. Mars, I'm having trouble seeing it. That's
Okay.
issue 1. So if you can make it larger, thank you. And you keep saying the word card as if it's credit debt rather than bank statements regarding checking and savings. Are you providing the court with information about credit cards, or are these bank statements regarding checking and savings?
Okay, Honor. I think that court is misled by Ms. Roberts with the goal to split accounts on credit cards and debit cards, which is wrongful because community assets and debts should be accounted all together. But if you're interested to see solely debit cards, let's check which of those statements are debit cards. And with that said, I do assume that this should be a debit card. Apologies. Okay, let's go through all the statements again, and you can just strike out as you do with requests for recusal. So is this debit or credit card, on your opinion? I assume it's probably credit card. It's probably credit card. It's probably credit card. This might be a debit card. Let's double check. Just in case, Your Honor, you could observe what was filed with the court. Okay, so whose name is on this statement? It's a petitioner. So ending balance in October 2022 is $477.38, and this is debit card.
Objection, that's irrelevant. The date is October 11th.
Let's say statements includes period from September 13 to October. So this balance is correct.
And the objection sustained because the balance must address date of separation. There's only 2 days covered within that period. It does not truly cover the period that is relevant for community properties, so the objection sustained.
It sounds like this objection is sustained because we have personal conflict of interest, Your Honor. And I do think this is the reason why you are sustaining all my statements without any exclusions.
Do you have any bank statements
Of course.
that cover the period from either before or on, more importantly, on the date of separation of September 15, 2022?
Of course.
I'm happy to consider any relevant evidence, but not evidence that doesn't cover that time period.
Your Honor, I would remind you that we have an obvious and undeniable personal conflict of interest with you. And you are striking out all evidences because you are ruling in favor of respondent. This is stated, this is recorded by reporter in the courtroom. And we cannot
Mr. Barnes,
proceed.
do you have any statements
Of course.
that will cover the period from the date of separation, September 15, 2022?
Yes. Starting from the date when respondent killed defenseless 95 years old senior woman with disabilities and abducted my son, who she detains illegally for more than a year, blocking all contact with father, yes, this is end in balance on Chase statement, and I think it's the same with Miss Roberts, right? $2,673.08. This is another balance that I think will be the same with Miss Roberts, and I will remind court and I will remind for record that Miss Roberts is taking only assets, absolutely disregarding debts. So yes, this balance was positive, and this balance was used to pay for rent for apartments that respondent captured by fraudulent restraining order that was signed by Judge James Towery, who recused very soon after signing fraudulent restraining order because of scandal related to bribery.
Assumes facts not in evidence, calls for speculation.
Sustained.
Okay, so balance probably corresponds to what Ms. Roberts stated. Those are statements from respondent. I will just show them because those few pieces were available, but I know that respondent refused to provide most of them. So there was beginning balance of 447, and there was balance of $90. Okay. And we are returning to equalization payment calculation sheet that must be a basis for deciding over equalization payments. And returning to it, I would remind that we have proved evidences of balances that you just saw about Chase debit card, Chase savings account, BFA debit on date of separation that commemorates memory of violence of respondent against my son and 95 years old senior woman with disabilities who was killed by respondent in cold blood.
Objection. Assumes facts not in evidence, non-response, lacks foundation.
So returning to balance.
The latter portion of the comments are stricken and the objection sustained.
Thank you, Honor. So returning to balances of assets and debts. We have total community balance for petitioner, $67,000, $97,700.
Waste of the court's time.
Sustained. Sustained. Do you have any, Mr. Mars, do you have any further testimony or proof on the issue of checking and savings accounts?
Your Honor, I would kindly ask you to just stay for a minute on this page, and you will be good to dismiss everything. So, the summary of community balances on the order.
So I'm going to take that as a no to my question. That do you have anything more to say about checking and savings accounts?
Yes, Your Honor. So, community balance was $67,000, $729.96. Community assets were $4,188.48. Community debts were $71,918.44.
Sustained. And so, Mr. Mars, at this time, I'm going to give you one more opportunity you are choosing to present the evidence the way you are demanding that the court address the evidence rather than specifically providing the court with information about checking and savings. So I'll give you one more opportunity. Is there any additional information you have specific to checking and savings that you'd ask the court to consider?
Yes, Your Honor. The specific number on the screen, $4,188.48, is the community assets balance, which is
Objection,
summary.
irrelevant, lacks foundation.
I'm sorry, Ms. Roberts, I couldn't hear the basis for the objection.
It's irrelevant and lacks foundation.
Well, it's difficult for the court to know whether it's relevant, but at this time, the court agrees that it lacks foundation. What do you base that $4,188.48 number, Mr. Mars?
Absolutely, Your Honor. So it is based on number of balances that Ms. Roberts and you just saw. It's relevant for Chase debit card, for Chase savings card, BFA debit card of Petitioner. And on another page.
Right. So Mr. Mars, again, that relates then to credit card debt.
No.
Which is not what we are addressing today.
Your Honor.
Not what we're addressing at
correct.
this moment.
That's
We are
not correct.
addressing.
Those are assets, Your Honor. You see assets, right? So it's respondent's assets on the date of separation. So respondent's assets, exactly as Ms. Roberts stated, were $617.71. And petitioner's assets, as Ms. Roberts stated, was $2,673.
Objection, irrelevant to the issue of the bank account balances and lacks foundation.
Correct.
Do we need to review
Sustained.
statements again? Ms. Roberts, do you have any objections regarding numbers that I provide in essence?
Yes, I
So
do.
Mr. Mars, and if I may, Mr. Mars, you're not going to question Ms. Roberts. You're either going to present information relevant to the specific issue we're addressing, or you're finished with your presentation of evidence on this issue.
Your Honor, to present relevant evidence, I need to understand what is objection of Ms. Roberts regarding numbers? What is wrong regarding assets numbers? Ms. Roberts?
Well, I think that she's made herself very clear with her objections that anytime you raise issues relating to debt or assets that go beyond the bank accounts, she is objecting. Because the only specific issue we're addressing at the moment are the bank accounts.
So this is very vague and unspecific objection. So I'm asking about specific objection, what is wrong with account balances? So, Your Honor, as you requested, I presented you balances of debit cards, right? Not credit cards, only debit cards. So those are assets. This is exactly what Ms. Roberts is saying. And I'm asking if Ms. Roberts agrees with this balance, which I think is the same on both sides. If Ms. Roberts sees difference, let's just double check bank statements. And I'm ready to present them.
Ms. Roberts has already provided the court with her position.
What is position?
I'm not gonna, and we are not in the middle of a settlement negotiation, Mr. Mars. It's really up to you to present what you think the court should adopt as the final amount on the date of separation, and then the court intends to divide it equally. So do you have any further information on that issue?
Thank you, Your Honor. So I do think that you can note $4,188.48 as community assets on the date of separation, and $71,918.44 as community debts on the date of separation.
Objection, irrelevant.
This is very vague objection, Your Honor. Apologies.
Whether or not something is relevant is not vague to the court, and the court is sustaining the objection. And with that, at this time, the court is going to grant Ms. Roberts' request that each party keep the accounts held in their name alone and Mr. Mars will pay an equalizing payment to Miss Mars for the community money in the bank accounts in the amount of $6,895.52.
Objection, Your
The
Honor.
court is ordering
no
that this
basis.
amount be paid within 45 days of today, but the court recognizes that we must now also address the issue of debt. And so the court is now going to turn to the issue of credit card debt. Beginning with you, Ms. Roberts, would you please provide the court, I'm going to give you about 15 minutes and then we're going to take our break. Please provide the court with evidence of any community credit card debt.
I know I'm having problems with the screen since I logged in. I don't appear able to share.
Oh, sorry.
Okay,
When you dropped off of Teams, I did not remember to make you a presenter again. You should now be able to share your screen.
Thank you. Yes. It looks like, excuse me, I lost the papers. I don't know where they disappeared to. Okay, I've located them. 1 minute, please. Okay, I'd like to draw the court's attention to Respondent's Exhibit M. This is a Bank of America credit card statement, account ending in 7126 in the name of Mr. Mars, that was produced in response to a discovery request. The previous balance on the account and the dates on this were August 26th through September 25th, 2022. Previous balance was $43.63.
Objection, Your Honor. Ms. Roberts is using a number that was presented before period of separation, and number that should be used is $74.96 on the end of separation.
All right, so the objection is to relevance, Ms. Roberts. Your response?
My response is completely relevant. The date of separation, September 15th, 2022, is included on this statement, as seen in page 3 of the statement. In addition to the previous balance of $43.63, there was a charge of $364.57 on September 12th, which was prior to the date of separation.
Objection. Ms. Roberts, could you please present the page that you are talking about?
It is on the page.
No, we are talking about Bank
September
of America. Objection. We are talking about Bank of America balance that should be $74.96. You are presenting another page.
And on September 11th, there was a charge of $38.96.
Ms. Roberts, to Mr. Marr's point, he's asking to see the balance. I believe on
Right there. It's the first page I covered.
Correct.
August 26th through September 25th, the previous balance, which would have been August 26, was $43.63.
Objection
To
irrelevant.
that,
Balance of August is irrelevant because date of separation ordered by court was September 15th to commemorate
This-
violence against 95 years old senior woman with disabilities. Ms. Roberts, could you
Okay,
please
so-
present page again?
So Mr. Mars, I believe that you very much have a point, but that's a point that should be raised on when you present your evidence. The court does not find, the court is going to overrule your objection that the whole statement is irrelevant and instead allow Ms. Roberts to explain what portions of this statement are relevant, as in what portion covers that September 15th, 2022 date of separation. Ms. Roberts, please continue.
yes, so again, on September 10th, there was a charge of $364.50, which was pre-date of separation. On September 11th, there was a charge of $38.96, which was pre-date of separation. There is a charge
Objection.
on the date of separation.
Ms. Roberts,
That
what is a
vagabond
bank?
in,
Objection.
which Ms. Mars would
Objection.
state is
Objection, Ms.
not
Roberts.
her bill,
Objection, Ms.
was
Roberts.
not to the benefit of the community.
Objection, Ms. Roberts. Could you please present which bank you are talking about? What is the account
I
number?
already did that, Mr. Mars.
Could you please scroll up a little bit?
That's the first thing stated, was Bank of America, account ending 7126,
Thank you.
credit card in your name. So if you take the previous balance plus the two charges pre-date of separation, the total on the card was $447.16.
Ms. Roberts, I heard 44716.
16.
Thank you.
I request that the court move exhibit M into evidence.
Any objection, Mr. Mars, to having exhibit M admitted?
No objections to exhibit, but I will remind that we have undeniable, impermissible personal conflict of interest with Judge Flint, who is legally obliged to recuse himself from this case, and we cannot proceed with trial. Thank you.
Exhibit M is admitted at this time.
Thank you. I draw the court's attention to exhibit N. This is a Freedom Chase account ending in 4255. This is in the name of Mr. Mars. It was a document produced in discovery. Again, we have to look at the statement dates. Yep. Unfortunately, I think there it is.
Ms. Roberts,
The
could you please
state-
scroll up
the
to
statement-
numbers, to balance, please?
The
Could you please,
statement appears to start
objection,
on
objection, Ms. Roberts. Could you please scroll up and state clearly in words what is a new balance on this statement?
She's not required to do that. Ms. Roberts, go ahead with
Certainly.
your
This-
information.
The statement date encompasses September 9th through October 5th, as indicated on page 3 of the statement.
Objection, Ms. Roberts. Those were community expenses. Why some numbers are crossed out as husband's expenses? That is weird.
This-
That is suspicious, I would say. That is
The
illegal.
objection is overruled. That's not a legal basis for an objection. Ms. Roberts, please continue with your presentation of evidence.
Yes, the previous balance, which would be September 9th, 2022, was $1,336.28. There were charges made on September 9th and September 10th, September 10th and September 15th. My client would testify that this HFHBR rentals is something that was not for the benefit of the community, that shortly before the parties separated, her husband took her and their small child out to a rental in Tracy and informed her that she was not going to live there. And that
Objection.
these charges for AFHBR rentals were for this rental in Tracy that was for the benefit of husband only.
Objection.
the only,
Objection. Ms. Roberts. So, Ms. Mars is lying to court regarding date of
Mr.
separation.
Mars, that's not a legal objection. Again, you're gonna have a chance to say what you want to say about the presentation of evidence, but that's not a legal objection.
Your Honor, may I
Ms.
clarify?
Roberts, go ahead.
May I clarify
Yes,
regarding
that's
specific expense?
the
Because
previous balance,
it alleges false allegations against me.
$1,336.
Mr. Mars, I'm putting you back on mute. I'm gonna allow Ms. Roberts to continue her presentation of evidence. Please hold yourself on mute unless you have a legal objection. Ms. Roberts, go ahead.
The previous balance on the Freedom Chase account was $1,336.28.
I'm sorry, the number again, I'm sorry.
I'm sorry, $1,336.28. There were additional charges before the date of separation of $24.53.
Objection. Numbers are falsified. Objection. Numbers are falsified, and false statements of respondent present those numbers
That is not a
incorrectly.
legal basis for an objection. That is your side of the case. Please hold that until it's your turn. Ms. Roberts, go ahead.
So the previous balance plus the additional charges would total $1,424.48 in community debt on the Chase credit card ending in 4255. And I request the court move Exhibit N into evidence.
Objection, Your Honor. This exhibit cannot be included because numbers are falsified and false statements support wrong numbers that cannot be used for equalization payment calculation. Thank you, Your Honor.
Thank you. So over objection, the court is going to admit Exhibit N.
I draw the court's attention to Exhibit O. This is an Apple Goldman Sachs credit card in the name of Mr. Mars, the petitioner. Again, this is September-October statement. October 31st balance was $19.73.
Objection. These numbers looks falsified. Could you please scroll back again?
That's not a legal basis for an objection, Mr. Mars. So again, you can make that an argument after she finishes her presentation. Go ahead, Ms. Roberts.
There are two charges pre-date of separation for $299 each, which would put a balance on September 15th, 2022 of $25.71.
Objection. Those numbers look falsified and cannot be included in evidence.
Objection's overruled.
I request the court move Exhibit O into evidence.
Mr. Mars, any objection to Exhibit O coming into evidence?
Yes, Your Honor. I do object against providing falsified bank statements, and I will remind that you deny my statements and my objections because of personal, obvious, and undeniable impermissible conflict of interest between you, Judge Flint, and me, petitioner on the case, which obliged you by the law to recuse yourself from this case. This matter cannot be heard by Judge Flint. We cannot proceed.
And
Thank you, Your Honor.
Exhibit O will be admitted over objection.
Thank you. I'd like to draw the court's attention to Exhibit P. This is a Walmart Capital One credit card ending in 1114. This again is in the name of petitioner Mr. Mars. The previous balance was $0. And it appears that the last charge before the date of separation was August 29th, 2022. So the balance on the card would be $21.15. And I request the court move Exhibit P into evidence.
Any objection, Mr. Mars?
No objections, numbers are correct. But I will remind that pursuant CCP 170.1 Section 6A3 and Section 3A, Judge Flint, who has personal conflict of interest with petitioner, is legally obliged to recuse. Thank you, Honor.
Exhibit P is admitted, and we are now going to take our 15-minute break. We'll start back up at about 11:15. Thank you.
Thank you.